Let's here to pass around the outline. Somebody didn't get one. Pass it around to help you follow along there. Although before I forget, I want to say I'm enthusiastically supporting Judge Daly in the race. So I know him; he's a good man. So I'm really encouraged to see that people are interested in the Constitution. It gets talked about quite a bit, but I'm concerned a lot of people don't really understand the history or what's at stake. The fact of the matter is we're drifting so far from the original principles of the Constitution that our liberty is in serious jeopardy. And so I thought it'd be interesting to give, I'm going to cover about 235 years in about 30 minutes, okay? So this is a very broad overview. I'm going to be talking in broad strokes. There are scholars who disagree with some of my conclusions, and that's fine. Don't take my word for it. I want to encourage you, I want to whet your appetite and encourage you to do your own reading about it. You can read the Federalist Papers. You can read notes that Madison took during the Constitutional Convention. I've got some other books listed in here. This is basically the front page of the outline I'm going to talk about. We're not talking all 4 pages. This is it, 1 page. But on the back of the first page is a list of books I'd encourage you to read that, in my opinion, I don't agree with everything they say, but they give a good, accurate, historical perspective of the Constitution. I've got some other provisions here I'm going to be talking about. Basically, the federal Constitution sets up the architecture for our country, for our government. And basically what it says is, we the people, based on the Declaration of Independence and what it says, get our rights from God, from the Creator, is how it was referred to in the Declaration, not from the government. What the founders came out from was a European model, where the king was in charge. He had judges that worked for him, and the people were basically the servants of the masters. What the founders said is, we the people are sovereign, we have rights from God, and in a just society, we surrender some of those to the government for the limited purpose of maintaining peace and protecting life, liberty, and the pursuit of happiness. So when the Constitution was written and when the Declaration was written, this was a radical change to the concept of government. It was something where people were going to be self-governing. And that's one of the keystone concepts in the Constitution, is that we are to be a nation of self-governing people. I am a public servant. Judge Daly is a public servant. We work for you. We only have authority because we've been given that in a limited measure by the people in order to help maintain order in society. And so on the top of your outline here, you see the Founding Fathers, left versus right. I want to tell you about how most of the Founding Fathers saw the political spectrum. Now, in current times, when we say left and right, we think of Democrats or progressives and Republicans or conservatives, and there are issues that fall in different places along that line. And if you go to Europe and look at European history, they have a different view of this continuum. They would put communists on the left and fascists, including Nazis, on the right. And that's their continuum over European history. The founders had a continuum that went from tyranny, let's say on the left, to anarchy on the right. That's their spectrum. So they would put both the Nazis and the communists and the progressives and the liberals, but not quite as far over here, under tyranny, because those are models of big government, central authority, very little rights for the people. If the other end of the spectrum is anarchy, that's no government, that's not good either, you have chaos. But what the founders wanted to do was go as far towards anarchy as they could and come back a little bit, have just enough government to protect individual liberties and life and the right to own private property without going towards tyranny. They feared tyranny. And so when they developed the Constitution, they were trying to set up a construct with checks and balances so that personal liberty would be protected and the government would be prevented from growing into a central power that could jeopardize the liberty of everybody. So we had the Declaration of Independence in 1776 after the Revolutionary War. Before we had the Constitution, in 1777, they developed something called the Articles of Confederation. And this was sort of like a constitution. It was an agreement between the states to have some agreement on some things of national interest, like to maintain an army, for example. But the Articles of Confederation didn't work. The federal government, under that set of articles, was so weak, it didn't have any power. They couldn't raise taxes. They couldn't pay the soldiers who had fought in the Revolutionary War, they couldn't pay soldiers, they had to raise an army again to defend themselves. And so from 1777 until the convention in 1787, we operated under this set of Articles of Confederation. It was state-based. Those were real states' rights. The states there had almost all of the power. Central government had very little. So when the convention was called, and it's not really properly referred to as a constitutional convention. The Constitution came out of it, but that wasn't the original plan. Matter of fact, the Constitution was kind of a secret plan some of the founders had before they went to the convention. It was announced as a federal convention or a great convention in Philadelphia for the purpose of amending the Articles of Confederation. So there was no public statement that they were going to scrap the Articles and write a new Constitution. The plan was to amend the Articles of Confederation to strengthen the federal government a little bit so it could operate effectively. So they called the convention. All the states sent delegates except Rhode Island. They smelled a rat. And they were right, there was a rat. The rat didn't make it through, but there were some rats planning to basically make a strong central government during the convention. So the other 12 states sent delegates. They meet in Philadelphia. Some of the folks who had a secret plan to scrap the Articles and develop the Constitution got all the delegates to agree that it would be a secret proceeding. And it was a good point. We need to be able to discuss freely our political ideologies and have a robust debate without worrying about what people on the outside are going to say. We don't want to be influenced by outside opinion while we're trying to come up with this document. Once the Constitution is fully drafted, it's going to circulate for a couple of years, and the states will have a chance to decide whether to ratify it or not. This is when the Federalist Papers are written during this 2-year period, so there's a debate about it. But in the writing section, which took place for about 3 months, the shades were drawn, the doors were closed, and they all took an oath of secrecy. So once they're in the secret closed area, Alexander Hamilton, who I respect as a founder, he was a soldier, but he had different ideas about government. He wanted big government. He wanted the president to serve for life. He wanted a national Congress that could, what they call, negative any state law. So he wanted, like a European model, a national Congress. It was a national government rather than a federal government. So a federal government is made up of states, and the states under the Constitution created the federal government. So the federal government is actually an agent of the states. It's been flipped now. Now the Fed is the boss, and the Fed can pretty much tell the states to do whatever the Fed wants the states to do. That was not the original plan. The original plan was the states, through their delegates, created the federal government. And in Article 1, Section 8, which is in here, they delegated 18 specific powers to the federal government. And basically the Constitution said the federal government can do these things and these things only. And the 10th Amendment says, just to make it perfectly clear, if the powers are not delegated to the federal government can't do it. And the states have reserved the rest of the powers to themselves and the people. So that's why I get my statement. The federal government under this Constitution can only do certain things. And the list of 18 things is pretty specific. It includes running a post office. So people complain about the post office. I'm like, actually, that's in the Constitution. I think we should fund it. Raising armies, maintaining an army, of course, central importance to national defense, patents, coining currency, treaties with foreign governments, and to maintain the federal government in Washington, D.C. It's actually stated not to be greater than 10 square miles, I think. So they want to keep that small in size as well as in power. So that was the debate. And if you read the notes that Madison took and others took during the convention, there's a big debate about how powerful should the central government be and how we have checks and balances in place. The founders understood that once people are in power, even good people, power corrupts. And Thomas Jefferson observed that before he was president. And once he became president, he actually said on a few occasions, I wish I didn't have so many chains binding me down. There's some things I'd like to do to make things go my way. So even the best among us are subject to being corrupted by power. And so that was part of the checks and balances that were in place there. So that's the debate number 3, national government versus federal republic. So states' rights under the 10th Amendment. Now some people like to make states' rights a dirty word. They go, well, that's what the southern states did in the slavery debate. States' rights is neutral. States' rights exist under the 10th Amendment. And it's true that before the Revolutionary War, the southern states did claim the right to have slaves as a matter of states' rights. Now we resolved that with the Civil War, and slavery was abolished, and the Constitution was amended. You got the Reconstruction Amendments, 13th, 14th, 15th Amendments, where the Constitution now says slavery is abolished in all states, and we give the federal government power essentially to prohibit slavery. So that was done the proper way. Slavery was not squarely addressed in the original Constitution because the southern states wouldn't agree, so the slavery was basically put off. It was pushed down the road, and it came to a head at the Civil War, and that's what resolved that as a nation. Interesting note on slavery, I've got Wisconsin Constitution in here. On the second page, Article 1, Section 2, slavery prohibited. Before a state could be admitted to the Union, it had to have a state constitution. And so Wisconsin, as you know, became a state in 1848, was admitted to the Constitution in 1848. Slavery has been prohibited in our Constitution since day one. And back in 1848, when we became a state, the federal government was pro-slavery. The U.S. Supreme Court had decided the Dred Scott case, which said that black people are not entitled to full personhood, and the federal government had passed what they called the Fugitive Slave Act. So slaves who would escape to Wisconsin for their freedom would be safe here under our Constitution. But the federal government had passed a law that said those slaves needed to be captured in Wisconsin and held for the masters to come get them and take them back. And that set up a pretty interesting confrontation. The Wisconsin Supreme Court actually declared that federal law unconstitutional. They nullified it. You may have heard of nullification. Nullification is defined basically as, in the government, an act of civil disobedience on based on a moral principle. And so the U.S. Supreme Court reversed the Wisconsin Supreme Court and said, no, you have to capture our slaves. You have, from southern states, you have to hold them in your jails until their masters come and get them. Well, that really set off a constitutional crisis, and it angered people in Wisconsin who understood that states' rights meant we had the right to be a self-governing people. We didn't want to have slavery in our state, and we didn't want to have anybody here trying to impose it on us. And it was about that time that the Republican Party was formed in Ripon, Wisconsin, not far from here. Late 1850s, mid-1850s. It was founded primarily by abolitionists. One of their main objectives in forming the Republican Party was to abolish slavery nationwide. And we know who the first Republican president was, Abraham Lincoln, and he was successful in doing that. And so somebody throws states' rights at you as being something that promotes slavery, you can correct them on that. It's nothing of the sort. It's actually what's in the Constitution, in the 10th Amendment. And something we can be proud about that is because it's the history of our state. And I mentioned the case here under number 5, the Joshua Glover case, 1855. If you want to look up and read about it, it's interesting reading. That's the Supremacy Clause. Some people will say, well, the Supremacy Clause in the Constitution says that all federal laws are superior to all state laws. That's not what it says. I gave you a copy of it here so you can read it. This is on the back of the first page. U.S. Constitution Supremacy Clause. This Constitution and the laws of the United States which shall be made in pursuance thereof. That's the critical language there. Made in pursuance thereof. If a federal law is made as authorized by the U.S. Constitution, yes, it is superior to state law. So if the state tried to make slavery legal, for example, the Supremacy Clause would say no. The 13th, 14th, and 15th Amendments say you can't do that. And if a state wanted to coin their own money, the Supremacy Clause would say no. Article 1, Section 8 says the U.S. Congress is in charge of making and printing money. So the Supremacy Clause is commonly misinterpreted by people who are in favor of central planning and a large central government, which is basically a progressive idea and a European model. Interpretation method, original meaning versus living constitution. You'll hear a lot about this in the judicial debates. Like Judge Daley, I know, is an original meaning judge. He goes with the original meaning regardless of what he personally believes the law should be. Right? Justice Bradley and Justice Abrahamson are living constitution people. And so they believe basically that the Constitution is a living, breathing, organic document that changes over time, and that only judges are wise enough to interpret what the Constitution should mean today. And they don't go so much with the words that were used. What's critical is what words did the founders use in the Constitution? What does it actually say? And what did those words mean when the Constitution was written? And you can see how this living, breathing Constitution allows courts, and in my opinion, to a great extent, the federal government, to basically steal power from the people. Because when we wrote the Constitution, we the people, that was basically, it's kind of like a contract. We the people have these God-given rights. And you as the federal government only have certain rights that we delegate to you by enumeration. And so a judge like Judge Daly or myself says, well, that's right, that's how it has to be interpreted, whether I agree with the outcome or not. A living, breathing constitutionalist says, well, they didn't have cell phones in 1787, therefore, I can determine what this Constitution actually means. Okay, then I thought I would take some non-controversial topics: abortion, gay marriage, and gun rights. Now, I'm more of a process guy than a policy guy. I'm more concerned that we follow the Constitution in making our policy decisions than what the policy decisions actually are. I think we have to go with the Constitution first. And every public official in Wisconsin, every other state, as far as I know, takes an oath to uphold the Constitution, so help me God. It doesn't say uphold what other people think the Constitution should say or any other personal preferences. It's uphold the Constitution, so help me God. So I'm going to disclose my views on these things, but I'm not pushing my views. Most of you will probably agree with me. I'm 100% pro-life, 100% traditional marriage, and 100% individual gun rights.
All right.
Okay. But these are not matters that are supposed to be governed by the federal government as it relates to individual rights. So abortion, for example, today you may have read, sadly, is the 42nd anniversary of Roe versus Wade. It was decided 42 years ago today. If you want to read a piece of comedy, read Roe versus Wade. And most liberal, I think, lawyers and judges even agree, it's really a piece of junk, legal opinion. Wisconsin, and it's on the back of the back page, still has abortion on the books. This is our abortion statute. It is a felony in Wisconsin for a person other than the pregnant woman to perform an abortion. The woman is not subject to criminal prosecution. In Roe versus Wade, the U.S. Supreme Court said people in Wisconsin and every other state in the union, you can't enforce this law. And read this. The life of the mother is an exception in here. Our state abortion law says if two doctors say an abortion is necessary to protect the life of the mother, it's not illegal. So the U.S. Supreme Court in Roe versus Wade looked to the Constitution to see whether it covered abortion. It doesn't. They went to something they call the penumbra. Do we have any astronomers here who knows what penumbra means? Penumbra is the shadow that's cast during the eclipse. So they found the right to privacy in the penumbra of the Constitution. That's what they said. That's the word that they used. They said, we think the federal government has authority to overrule the will of the people. I don't know if every state had an abortion statute. I think they all did, or most all of them did. And with the stroke of a pen, those 7 justices who wrote that opinion overruled the will of the people in all the states that had that statute. And so you can see how power is now being taken from the people and taken by the court to the federal government. So-called gay marriage. Marriage has always been a state issue. You don't have federal divorce courts. There's nothing in the Constitution that says the federal government is allowed to decide how marriage is defined. So, being a states' rights constitutional guy, I think if a state wants to have a traditional marriage rule like we do, that should be that state's option. And to be intellectually honest, if a state wants to have a gay marriage rule, they should have that option. I'm not going to tell somebody in New York City or San Francisco how they should live their lives. And how about this? They'll try to come here and tell me how to live my life. And the beauty of the republic is that the states are like different little experiments. If you don't like the way things are in your state, you can either work to change them or you can move. I got a funny story with my wife Terry here. Say hi, Terry. We were driving our youngest daughter down to Texas to go to school, and normally we go through Illinois, and the concealed carry law had just passed, and so I of course had my little hanging with me and stuff, and we're driving through Prairie du Chien and going into Iowa. She goes, why do we go through Illinois? We always go through Illinois. I said, because they don't have a concealed carry law, and that's a state I'm just going to avoid. Iowa respects my right, and so do the other states. But here's something that I think a lot of you might disagree with me on. And I support individual gun rights 100%, like I say. The Second Amendment was not intended to apply to state governments. It limited Congress's authority to control individual gun rights. When it says shall not be infringed, that means the U.S. government shall not infringe in any way, shape, or form the individual's right to own a gun. Until 2010, you may have heard about the McDonald decision, involving the guy in Chicago who had a gun, and Chicago made handguns basically illegal. The federal court in that case said that the Second Amendment guaranteed that person the right to have a gun in his apartment, and the city's law to the contrary was unconstitutional. I disagree with that. The people of Illinois don't want to have a concealed carry law. If the people of Chicago don't want to allow handguns, that's unwise, but that's their business. So short term, yes, it's good. If you like guns, live in Illinois, you get guns. But think about what's really happened during the big picture. We have now given the federal government the authority to control handguns. So that's how they normally sneak in the back door. We're here to protect your rights. It goes on in the Constitution, we're here to protect your civil rights. We're going to apply the Bill of Rights against the states. Once they're in that door, you can't get them back out. Some people say to me, I wish we had a uniform concealed carry law, so no matter what state I went to, I wouldn't have to do my research before I drive over there. Terrible idea. I've got the Wisconsin Constitution. Right to keep and bear arms, the back page, Article 1, Section 25. Who do you trust more to protect your gun rights? Soon-to-be Justice Daley and Michael Gableman and Patience Rogensack and Governor Walker and the people that we elect locally who are subject to being reelected or not reelected if they don't protect their rights, or federal judges appointed for life who are not accountable to anybody. So it's really a question of who do you trust more to protect your rights? Your state government or your federal government? So people say, well, the feds have to come in case the state violates somebody's rights. You got to decide who you're going to trust more, and the founders believe in local control. I can affect my town chairman election, or my county supervisor election, or my governor election, or my Supreme Court election a lot more effectively than I can what's going on in Washington, D.C. I have almost no control over who's the president of the United States, or even who my senator is. Those will become basically national elections as well. So usually people throw tomatoes when I say the Second Amendment doesn't apply against the states, but I think if you read the Constitution correctly, that's the way that it was meant to be. And there's something called the incorporation doctrine. The Supreme Court basically made this up about 100 years ago, that allows them to apply the Bill of Rights against the individual states. The First Amendment says Congress shall make no law restricting free speech. That means U.S. Congress. That was a restriction on the U.S. Congress. And by incorporating that against the states, they've really restricted our rights as individuals. You can't say a prayer, you can't say a Christian prayer like we did tonight at a football game in Texas, because the U.S. Supreme Court, under the First Amendment, has decided they know better than the people in the state of Texas that want to say prayers at their public school football game. And so that's another interesting thing, and that's part of the flip that's happened. The states created the federal government as its agent, and now it's flipped over the course of the past 230 years, where the states are really subservient to the feds. And when you combine the ability to print money and a huge unconstitutional entitlement program, you see where you end up. I forget how big the debt is. It's 18 trillion. If the states were running the entitlement programs, you wouldn't have that big of a deficit because you can't print your money. So I didn't have a problem with Romneycare. If you want to have government health care in Massachusetts, go for it. I won't live there. But when you make it a national program, you're going to run into these huge deficits. Another interesting amendment, 17th Amendment. 17th Amendment changed how U.S. senators are elected. On the original Constitution, our state legislators picked the U.S. senators. So we elect our state Senate and our state Assembly. They would select 2 people to go to Washington, D.C. to be our U.S. senators. And if those U.S. senators were not doing what's best for Wisconsin, we could yank them back. I'd say with a phone call, they didn't have phones then. In case you said
no cell phone.
Yeah, Wells Fargo, yeah. So they yanked them back. And the 17th Amendment, progressives, who wanted a more centralized power, central power government, wanted to make those elections for senator popular elections. See what's happened now. Our Senate elections are national affairs. when there's a senator running in a state where it's a pivotal state, tens or hundreds of millions of dollars can flow in from outside the state, electing that person not because of what they do for that state, but what they can do for the national balance of power. That's another way we strayed from the original constitutional design. And there used to be, I think, more respect for the constitutional process. I got prohibition in here. When people wanted to make alcohol illegal around the country, I'm not saying it was a good idea, but they at least have respect for the process. They passed a constitutional amendment. We want to give the federal government the ability to control alcohol. We're going to propose an amendment, ratify it, and pass it. And they figured out that wasn't a good idea. They passed another amendment, which reversed it. Something else beautiful about the Constitution, the amendments stay in there. We don't go back and erase anything. You can see the history from day one to the current day and see what's been changed over the years. So we record our mistakes for the sake of future generations. So that's basically the outline. Does anybody have any questions or disagreements? Feel free to disagree. There are other people that don't see things the way I see them.
I think this is a good thing because so often we get caught up in the rhetoric, and unless you really start looking at the Constitution and start hearing the other arguments, you realize, well, wait a minute, this is not a good thing, you know, like, in case, talking, the, I forget the gentleman's name, but the basketball owner, who said something in private, but it was recorded and was put out there, and then he was told, you know, made to give up his business. But when you look at it, that's against the Constitution, what our founding fathers did, because they deprived him of his livelihood. Just because of something he said in private, they're leaking public. And I like this fact that what you've done tonight, because it opens up another way of looking at things and things that we should all be aware of it. I don't think it's being taught in schools.
No, it's not. That's for sure.
And I wonder how we can turn it around. And you said the process was where we did something with prohibition, and they realized we're wrong, and we did it, and we changed it. How are we going to be able to change this if people aren't educated as to what the original intent was?
Start with your own party. Now, we're nonpartisan judges of Wisconsin. We can't belong to a party. And I'll talk to the Democrats. They'll never invite me, but I'd be happy to invite you. In the Republican Party, you have constitutional conservatives, and you also have progressives. And I think it's just as bad for a Republican to go to D.C. to use the huge bureaucracy there to impose his or her political agendas on the states through an unconstitutional process as it would for a Democrat. Democrats tend to be much more guilty of that. Part of their ideology is central planning, big national government. But some Republicans do that as well. So in your own party, with your own candidates, I'd ask them, have you read this? Do you plan to really follow it? Do you take your oath to God seriously? And we don't want to send you to Washington, D.C. if you're going to use that position to exploit the distortion of the U.S. Constitution for that purpose. So that's where I think we start. And now these books I listed are really, you ever Mark Levin? I got a couple of these books in here. Yeah. Really interesting read. This is not dry stuff. I got a Glenn Beck book on here. I got Judge Andrew Napolitano. Yeah. This is kind of seen as hard right stuff. You get a lot of so-called conservatives say this is too far right. But these guys, by and large, are correct on the Constitution. So I'd encourage you to read that and do your own research. So that's right. I think it's good to talk about it, keep people interested. Yes.
The 10th Amendment you mentioned on number 4.
Yes.
I can't remember your specific example. I think it's slavery. But the federal government can't force the state to do something that I'm thinking of Obama, which is being a violation.
Right.
The federal government will force this on the nation, every state independently.
Right. Well, the important thing about the 10th Amendment is that it clarifies what the Constitution says in the part before the amendment. It uses the word delegated. Power is not delegated to the U.S. When you delegate something, you're giving a specific grant of authority. If I delegate you as my power of attorney, for certain purposes, you can do those actions, but nothing more. And so the 10th Amendment says it is not. Because people say, well, there's a general welfare clause, a necessary proper clause, and these clauses mean the federal government can do whatever it needs to do as long as it's in the best interest of the country. But that doesn't make sense. When they put something as specific as the post office in there, and the military and coining money, then you really read the General Welfare Clause correctly to say you can do these 18 things as required for the general welfare of the country. And so the 10th Amendment does say that the states reserve the rights and the powers that are not given to the federal government. So as it relates to slavery, slavery was not dealt with in the Constitution. It was mentioned, but it wasn't made legal or illegal. The northern state delegates knew if slavery was outlawed in the Constitution, the southern states would not have signed on, wouldn't have had a country. So they did put some provision. One provision says slave trade can be outlawed like 20 years from now. So they put steps in. It was a step towards abolition of slavery, but they couldn't get it done then. And so the 10th Amendment, that did give the southern states that argument, actually, that they had the right of the Constitution. And that's why we had to have a war. It was a moral imperative to abolish slavery. And they did have this argument. So they did use the states' rights argument. And technically, in the sense, they were correct. Nothing in the Constitution said they couldn't do it. So that's why we had to get rid of slavery through the war and the amendment process. Yes.
I have a question maybe for both of you. I've said it on the court proceedings for a few different lockout, and almost every time cases come up, and you have a judge say, it gives that this number of times, I'm going to have to sentence you to this. I don't think it makes sense, but under the law, I need to do this. And there's a real process person who needs to do it. Sometimes it seems like, some things just don't make sense in certain cases. And I'm wondering if there's any informal or formal mechanism for judges to be able to express to legislators, and I think this is really complicated.
I call them all the time.
You do? Okay,
Yeah.
so you do.
Not every week, but I'd say once or twice a year I'll call. They've actually had bills changed because judges have called. I've served on committees, so you've been on
Okay, that makes me feel good, because, I've heard words like, if you don't like that, I encourage you to talk to representatives. So that's great, if you get the feedback.
And they call me too. I get calls once in a while. You probably do 2 times a year. There's a lawmaker who I'll know what I have a relationship with. Hey, we're thinking about changing this. How will that affect how things really happen in the trenches? So there is that.
But I'm thinking about like the free strikes laws and stuff like that, where people get a third felony for seemingly minor things.
That doesn't happen in Wisconsin.
We
don't have that here.
But those types of things, where
Right.
under the law you have to do.
They have to do it. And
That makes me feel good.
yes.
On your last thing on your outline, it says constitutional conservative versus political conservative.
Oh, yeah.
Can you address that?
Sure. It's tempting to try to elect judges who agree with your politics, so they will further your political objectives from the bench. I think that's a mistake. Now, most constitutional conservatives, like myself and Judge Daly, are also political conservatives because those go together. I do know some judges who are politically liberal, but judicially conservative. Not many of them, there's a few of them. So they will actually uphold the law whether they agree with it or not. And that judge, in my opinion, is better than a political conservative judge